Chapter 11 cases, the principle at the bottom, the question is, how are creditors going to get paid? How much are they going to get paid? When are they going to get paid? And very often, and I think likely in this case, another question is, who's going to end up controlling the company? And we'll talk about that a little bit later. Chapter 11 is a scary thing, and you read about it in the newspaper. If you don't read the newspaper and don't hear about the news, you might not notice it happen. In many ways, a company in Chapter 11 operates just as it did before bankruptcy. In most cases, after a company files Chapter 11, management stays the same. Now, there are exceptions to all of these, but in most cases, management will stay the same. The company will continue to operate its business. It'll pay wages. It'll pay vendors. It'll pay suppliers. And it will continue to operate business as it did before. Ordinary transactions that the company engages in as a matter of course, buying and selling, it can continue to engage in. But any non-ordinary course transaction, for instance, a big asset sale or hiring or big acquisition, any non-ordinary course transaction requires approval of the bankruptcy court. In other words, the bankruptcy court allows the company to operate normally, but if the company is going to do anything extraordinary or unusual, it needs bankruptcy court approval, and the creditors, the people who are owed the money, get a chance to comment. I was going to put one other thing on this board, and let's see if this green pen works. This green line is the day that they filed for bankruptcy. This is before or pre, and this is after or post. I should have written before and after. I've talked about protection from creditors. That's called the automatic stay. Creditors are blocked by law from attempting to collect their debts. Any debt owed before the bankruptcy. After the bankruptcy, the company will continue to pay. So, it happens in every bankruptcy. If company X sells widgets to Palco, and those widgets are delivered the day before bankruptcy, company X has a pre-petition claim and will not be paid until bankruptcy is over, because claims that arise before the bankruptcy case are just like the notes. They get handled at the arrest of the case. But if those widgets are delivered here, even if the truck was delayed, if the widgets are delivered on the day after, they have to pay for benefits they receive after the bankruptcy case starts. So there's a demarcation line. Pre-petition claims have to wait till the end of the case. That's why if the company's going to do something unusual, the court wants to know about it, the court gets to approve it, and creditors, these people who haven't received their payments, get to comment on it. Talked about the bankruptcy court. The bankruptcy court has, these are the principal participants in a Chapter 11 case. Again, I apologize for my handwriting, but I'll tell you what they are. This is the debtors. The United States trustee is an officer, and he's second on the list, but he's not that important, but I put him up here because I got to explain something about him. It's an officer in the Department of Justice, and he has some supervisory duties, but one thing he does is appoint the creditors committee. And the creditors committee is an official group of unsecured creditors of the largest, some of the largest creditors in the case. That's an official group that meets regularly, meets with the debtors, investigates the debtors, considers their proposals. They hire lawyers and other financial advisors, all of whom are paid by Palco. So Palco has to pay for its own lawyers and advisors. The creditors committee's lawyers and advisors are also paid by PALCO. But this is an unsecured creditors committee. So the note holders aren't on that committee because their claims are secured by the trees. The note holders, however, for several years, because of PALCO's financial difficulty, the note holders have had an unofficial committee, which has met regularly, has met with PALCO, and in fact, a year or so ago, you may recall, I think it was a year ago last fall, there was a lot of talk between PALCO and the note holders about a resolution of the dispute between them, and they almost reached an agreement. This committee's been around for quite a while. It's unofficial. At this point, it pays for its own advisors, but this is a group that represents the $716 million in bond debt, and they're very active in the case. And then you have the court. The court is there to resolve disputes. It's there to approve any non-ordinary transactions that the debtor is involved in, and a ton of other stuff, including some of the things you've been reading about in the paper. But what's the principal job of these groups? The principal job of the committees is, and the bankruptcy court directs the committees to do this, to investigate the debtor's assets and business, and to negotiate the plan. And the second, part 2 of this session, we're going to talk about the plan. One of the big advantages to filing bankruptcy is that you can stop making payments. They don't have to make payments on the notes. They don't have to make payments on any pre-petition claims. All they have to do is pay their costs going forward. But there are disadvantages to bankruptcy as well, and one is you got to pay these guys legal expenses who are fighting with you, and you are subject to broad a level of investigation by the creditors committee and probably the note holders committee as well. Chapter 11 is sometimes described as life in a fishbowl, and these committees and representatives of creditors have the right to go in and look at PALCO's books and records, investigate transactions, see who's done what when, and make recommendations. So that's an important role that they play. I got one other thing I wanted to talk about in this section, and that is this venue issue. You know that they filed in Corpus Christi. When I first heard that they filed in Corpus Christi, my first question was the court in Puerto Rico closed? And here's how it works. You have to file where your principal place of business is. If XYZ Corporation is based in Los Angeles, it has to file in Los Angeles. If it's based in New York City, it has to file in New York City. That's the rule. But if you have 2 or more related companies that file, and one of them is based in New York, and one of them is based in LA, how do you pick? You can't, if you have 2 related companies that file, they should both be in the same court under the same judge, so that they should be together. So how do you pick, New York or LA? Well, the answer is the management gets to pick. So if you have related cases, and they are in different locations, management gets to pick which court they file in. And here, we had 4 or 5 companies, all located here, but you had one located in Corpus Christi, Texas, more or less located in Corpus Christi, Texas. And they got to choose, okay, we'll file that company in Corpus Christi, and by virtue of having one company file in Corpus Christi, everybody got to